The U.S. Supreme Court has upheld the Affordable Care Act. For more on this ruling now, we want to bring in Jessica Levinson. She's a CBS News legal contributor and a professor at Loyola Law School.
So what happened, of course, is that the Affordable Care Act is President Obama's crowning legislative achievement. And the minute he signed it, the briefs were ready to challenge this act. And it's already been to the Supreme Court, actually, a couple of times. But the big time was in 2012, where the court said, you know what, we are upholding the Affordable Care Act. And as you said, we're upholding the individual mandate, that part of the law that said, if you don't buy health insurance, then you have to pay a penalty. And why did the court say we're upholding that? They said we're upholding it in the Constitution. It says Congress has taxing authority. I actually just am about to teach this to my students tonight. It couldn't be timelier. And so the court said, look, it looks like a tax. Congress has taxation authority. It's permissible. Fast forward to the Trump administration, Congress zeroes out that tax, zeroes out the penalty and says you don't have to pay anything if you don't buy health insurance. Immediately, again, there are challenges that say, well, if it's zero, if you have to pay $0 for not buying health insurance, then the individual mandate is unconstitutional. You can't hang your hat on the taxation clause anymore. And this challenge, the big one that goes up to the Fifth Circuit, which is the circuit that takes challenges from Texas, says, and the rest of the Affordable Care Act is unconstitutional as well. So that was why so many people were worried. So many people whose health insurance depends on the standing, the constitutionality of the Affordable Care Act were worried, well, is this entire statute going to be declared unconstitutional? The case again goes to the Supreme Court. And what do we see today? A classic Supreme Court punt, where they say, you know what, we're not even getting to the question of the individual mandate. We're not getting to the taxation clause. We're not talking about the rest of the statute. The people who sued, they don't get to come into federal court because they don't have the proper, it's called standing. It's a doctrine that says if you want to come into federal court, you need to be the right person. You have to have the right type of injury. And if you win, you have to have the right type of resolution.
So, Jessica, as we were saying, the ruling was 7-2. Justices Gorsuch and Alito dissented. What was their dissension, or the crux of their dissension?
The crux of the dissension being that there is, in fact, standing in this case, and that they should reach what we call the merits of the case, get past this procedural issue of standing. And I think there's very little question, or I would say there's little question in my mind that they would have viewed the individual mandate as constitutionally suspect, which is, I guess, just a law professor way of saying not legal under the current framework. So the dissent being kind of, I want to get to the big issues here. Let's not do what the Supreme Court often does, which is just to say, oh, you're not the right parties. And the majority, responds in this fairly lengthy opinion, which obviously I haven't had a chance to read the whole thing yet, from Justice Breyer saying, here are all the reasons why both the individual the individual plaintiffs and the state plaintiffs don't have standing to sue. They don't have enough of an injury. So this is a case actually that's not probably going to be taught in constitutional law. It might be taught in civil procedure or the very beginning of constitutional law. It's not going to get into all those issues we thought about. Does Congress have this power? How much power does Congress have if one part of the statute is declared unconstitutional? It's all about saying to the red states who sued, you're not the right person to bring this case.
So does this then put to bed any future challenges when it comes to the Affordable Care Act, or are there other ones kind of working their way through the system?
I lack a lot of wisdom, but in this case, I feel that I can say it doesn't put this to bed. If there's one thing that's sure, I think there are a number of issues where we're just going to keep seeing litigation. Now, the ACA, the Affordable Care Act, is one of them. This is something that you can basically bet if we hear about it on the campaign trail, then there might also be litigation. So there are certainly suits. This was the big one, however. But again, there are certain areas that we can think about where we're always going to see litigation: voting rights, abortion rights, Second Amendment, religious freedom. These are kind of evergreens. Now, of course, if you'll allow me a moment, Congress could say enough, and Congress could pass a new piece of healthcare reform. This is not this piece of legislation, it's a statute. So if Congress really wants to end so much of the litigation trying to either get at portions of the Affordable Care Act, trying to overturn them, or trying to have a full frontal assault on the Affordable Care Act, Congress could actually just write a new statute that frankly might stand up to challenge better. But that's a political question, and I don't see that happening.
Jessica, there are a number of other major decisions that we are expecting. We did get a second opinion. The Supreme Court has sided with the food giants Nestle and Cargill in a lawsuit that was brought by, this is a really interesting case, 6 citizens of Mali who say that the companies facilitated human rights abuses by purchasing cocoa from plantations in the Ivory Coast, where they say they were enslaved as children. And why I think this is interesting is that the Supreme Court, which has rejected, I guess, this case brought by the plaintiffs, is that there have been recently, in as far back as the 1980s, the use of something that I didn't know a lot about, and I'm looking it up again because I just saw it a couple of days ago in preparation of this case, the Alien Tort Statute, which is, get this, Anne-Marie, this is a statute from 1789 that apparently allows federal district courts to hear, and this is quoting the statute, any civil action by an alien for a tort only committed in violation of the law of nations or treaty of the United States. And I guess since the 1980s, Jessica, a number of people have used this to bring human trafficking or human rights abuse cases before the Supreme Court. But generally, the court rejects those cases. Why is that?
Generally, the court rejects those cases on the philosophy that the statute doesn't reach that type of behavior. And you sometimes have this problem with a very old statute where it's not clear what was intended and or if it was intended to cover the activities that were complained of here. This was also an interesting case because I believe, and we're going on my memory, that it was former acting Solicitor General Neil Katyal, who's known as a left of center now attorney who speaks out often, for instance, against former President Trump, who argued this on behalf of the corporations.
That's correct.
And he said, this isn't a political cause. This is about looking at the statute. And also, of course, he's a lawyer who represents clients. And he made a very impassioned argument that we all got to listen to as a result of the new Supreme Court oral arguments, where we can all listen in on the phone, and essentially said that the statute doesn't stretch and reach this. When you're talking about the particular statute, I'm remembering that way back 100,000 years ago, when I was in law school writing onto my law school competition, I think this was the question because it had only at this point been used for about 20, 25 years, which is, are we going to move forward and continue using the statute? And Vlad, you're exactly right that the cases come under the statute because there's really no other place to try and bring a case that looks like this one, where you have similarly situated facts. But the courts really don't want to expand the reach of the statute much further. So
Jessica, because and this is what Mr. Katyal said at one point. This is a quote from the New York Times. The claim plaintiffs bring alleges something horrific, that locators in Mali sold them as children to an Ivorian farm where overseers forced them to work. But the defendants are not the locators, not the overseers, and not the farm. So for my very small brain, I'm not a lawyer, I'm trying to understand, well, if Nestle or Cargill is sourcing these cocoa beans from these farms that has employed children who are enslaved, in fact, do they not bear some responsibility? And the court is basically saying, no, they don't?
The court is basically saying, no, they don't. And this is actually, it's not obviously a small brain question at all. This is a question that comes up not just in this statute, which I would try and describe most generally as a question of at what point, even if you are aware of hugely problematic behavior, at what point does a defendant's liability kick in? And this is a question that we see across the legal spectrum in a number of different situations, which is essentially, do you have to just know that this is how I source my product, and it's hugely problematic, and the mere awareness or knowledge is enough for liability? Here, the court basically saying, no, you weren't the primary actors here. And then in other cases, we ask, do you have to have actually been the person acting, or to have been the one directing that acting? I'm thinking of another situation. We have this, an analogy, for instance, in laws against the publishers and editors whose photographers and reporters might engage in privacy torts. And it's obviously, I don't want anybody to think that I'm making an analogy between an invasion of privacy and enslaving children or treating children this way. But the legal question is similar in if you just receive a picture, or if you just receive a product, or just receive an article, for instance, from somebody who you knew committed a tort, is that enough for liability? And the answer pretty clearly across different legal areas is no. You have to been either the person who engaged in this activity, who hired the children, who created the system, who actually took the picture, or who told somebody to take the picture. And so that's basically what Neil Katyal and what the court's saying here is, we're not going to touch the defendants in this case. They didn't engage in the behavior that's subject to the statute.
There's another case that I believe we have a decision on, but I've been searching. I can't find what the decision is, so maybe the producers can kind of talk to us in our ear. But it has to do with religious rights. This is the one out of Philadelphia. At the core of it, it was a religious organization that Philadelphia hires other organizations to help find foster parents. And this religious Catholic organization did not want to place children in same-sex households. And so this case has made its way all the way to the Supreme Court. Vlad, sorry, do you have a little more information than me?
The court has actually ruled in favor of the Catholic Social Services Organization that sued the city of Philadelphia after it was excluded, as you say, Anne-Marie, from this foster care program because the organization refused to certify same-sex couples as foster parents. So what should we know and understand about this decision, Jessica?
So it's strange to ask you to tell me, but who actually authored this decision? Because then I think I can maybe help predict how narrowly or broadly it was written.
Let us take a look.
Of course,
this is what happened. Throwing this at you, Jessica.
Yeah, because it's breaking as we're speaking.
I can describe the background of the case is exactly what you said, which is I believe it's City of Fulton, and they have an anti-discrimination law where they contract with private companies to help them in their foster care work. And their anti-discrimination law says you can't discriminate based on LGBTQ status. And there's this religious agency, and it's a Catholic agency, and they said, we don't want to place children with same-sex couples. So we're happy to help you, but we don't want to be part of placing children with two men
Jessica,
or
let me
two
just,
women.
so you know, it's unanimous. Yeah. It is a unanimous decision in favor of the Catholic agency that refuses to work with those same-sex couples.
Yes, and so this is, I have to admit, I wish I could say, I'm not surprised at all. I'm surprised that it's unanimous, but I'm not surprised by the decision because what we've seen, and I think we got a chance to talk about this a little bit last week, but what we've seen from this court is that they're very protective of anybody who comes into court and says, my First Amendment rights, and particularly the part of the First Amendment that protects the freedom of religion, the free exercise of religion, I'm worried about my First Amendment rights. And so what the court is saying here is, we know, City of Philadelphia, that you have this anti-discrimination law, but there is this constitutional protection for religious freedom, and that's going to overcome your anti-discrimination law. Why was this a fairly, why do I have a pre-write on this, basically? Why was this a fair prediction? In part, not just because it's a conservative Supreme Court, but we can look back to a couple of different areas. We can look back to the COVID decisions that I think we got to talk about briefly, where the court said, restrictions that burden your ability to worship, go to a church, temple, or mosque, we're very suspicious of those. And we can also look back a few years to decisions where you had the liberal justices, you had Justice Kagan say things like, I'm really worried about the religious objectors here. So it's an interesting lesson for all of us, which is we think that these big issues always break 5-4 or now 6-3. But conservative legal thought is not the same as having a conservative political position. And I think that's part of the lesson from today.
Yeah, I'm sort of reading through it here.
I think there are no other decisions
yeah,
that are coming down today.
We have,
anyway.
as they say, the R number. Well,
Is that what?
For June 18th, that's a big day. The ACA is upheld. The Fulton case, the religious objectors are vindicated, I would say. And what it means going forward, I think, obviously I haven't had a moment to read the opinion, but what it means going forward is that if you're a plaintiff who is facing a type of anti-discrimination law on the local level, on the state level, or maybe even on the federal level, and you say, yes, but I'm worried about my religious rights in this case. We can think back to the Hobby Lobby decision from a few years ago, the small corporation that said we don't want to have to provide birth control to our members. We can think back to a few school cases dealing with public funding. We can think back to the COVID cases. In all those situations, we have a Supreme Court saying, you're right, if you walk in here and say, I'm worried about my religious freedom, you're going to win. And we're going to see more of that going forward.
Yeah, let me just, for our viewers' benefit, and I think it's interesting, Jessica, because of what you were talking about, religious freedom and the tilt of this court, but it's a unanimous decision. And you said you were not surprised by the decision, but you were surprised that it was unanimous. So here's what the court says at the end. As Philadelphia acknowledges, CSS, which is the Catholic organization, has long been a point of light in the city's foster care system. CSS seeks only an accommodation that will allow it to continue serving the children of Philadelphia in a manner consistent with its religious beliefs. It does not seek to impose those beliefs on anyone else. The refusal of Philadelphia to contract with CSS for the provision of foster care services, unless it agrees to certify same-sex couples as foster parents, cannot survive strict scrutiny and violates the First Amendment. In view of our conclusion that the actions of the city violate the Free Exercise Clause, we need not consider whether they also violate the Free Speech Clause. And so that's how they're sort of deciding it at the very end, unanimously. And it does strike me, and based on our discussion and just reading through this briefly, that it is about religious freedom. And if the court is forced to decide between religious freedom and discrimination, they generally tend to rule in favor of religious freedom. But that does perhaps worry some people, because then religion, whatever it may be, can be used often to discriminate against somebody. I mean, any religion, ultimately.
That's right. I think this was, in hindsight, not the best case for... It was a great case if you are a religious objector to bring, but not the best case for the city of Philadelphia, in the sense that the way this was structured, I think it wasn't well set up to say that the anti-discrimination law had to overcome the religious objection here. And I want to just point out, you use the word strict scrutiny, and I think that's such an important thing to remember when we're talking about these religious freedom cases, which is whenever a case kind of walks into court, a couple of things have to happen. First, as we just talked about from the Affordable Care Act case, you have to have standing. You have to be able to then open the courthouse doors. Once you walk into the courthouse doors, then the judges have to decide, well, how much do we really trust the government here? Are we deferential to the government? Typically that happens in the situation of, for instance, economic regulations, where the government says, the justices say, if you have a good reason for doing it, we're going to trust you. But then when there's any piece of legislation or regulation that is alleged to affect your individual rights, and particularly your individual right to freedom of religion, the free exercise clause, then the justices are going to really open the hood and they're going to look and say, are you sure you have a very good reason for this? And that's what we mean by strict scrutiny. It basically means two things: that the government has to have a really important, meaning compelling reason to do this, and there's no other way to achieve their anti-discrimination ends. And in this situation, the anti-discrimination law could not overcome that very high threshold. So often in Supreme Court cases, the most important thing is, what's that standard of review we're going to use? How much are the justices either going to trust or be very suspicious of what the government's doing? And when it comes to religious freedom cases, the court has said we need to be suspicious. And I think that's largely what we see here, is the court truly applying the strict scrutiny.
So Jessica, one of the other big cases that we're still waiting for, I believe, is a voting rights case, Baranovich versus the Democratic National Committee, having to do with how ballots are handled in Arizona. Can you kind of flesh that out for us?
Yeah, absolutely. There are two big provisions in that Arizona case that are at issue. The first one deals with out-of-precinct voting on Election Day. So let's say it's Election Day, you haven't voted early, you want to vote in person, you go and you accidentally go to the wrong precinct. You thought that this elementary school gym was your precinct, but you're wrong and you're out of district. Your entire ballot is trashed in Arizona because you went to the wrong district, you went to the wrong precinct. The question in the case is whether or not that Arizona practice that eliminates, it's not just vote dilution, it's vote elimination, that eliminates your entire vote, whether or not that violates Section 2 of the Voting Rights Act. That's basically the only part of the Voting Rights Act that remains after 2013, when the Supreme Court struck down the other half in a case called Shelby County. So that's one provision of the Arizona law. The other provision deals with something called ballot harvesting. Ballot harvesting is typically kind of a pejorative term, but what it really means is you want to vote early and you want to hand your ballot to someone. In Arizona, that to someone is a fairly small group of people. It can only really be a family member, household member, or I think a caregiver as well. And that was also challenged on the idea that it really heavily burdens certain people who live in certain situations where it's hard to find somebody who fits into that class of people who can take your ballot in. That's also a challenge based on Section 2 of the Voting Rights Act. That's a big one that we're waiting for, of course, because there are so many voting laws, voting bills that are pending throughout the nation, and people want to see, well, what's the Supreme Court's thinking on not directly analogous, but on similar issues. I suspect that this court will uphold both of those provisions. If you listened in to the telephonic oral arguments, you heard, I think, at least 5 of the justices saying, is it really that much of a burden? Is it really that bad that you just have to go to the right precinct? Is it really that bad that you have to either, put your ballot, vote a different way, or find somebody who fits in this category to return that ballot? So I think that those two laws will be upheld. And of course, this is another situation where Congress could act. Congress could decide to implement a nationwide Voting Rights Act, either H.R. 1 or the John Lewis Voting Rights Act or something else. But this is a situation where we're looking at those two state laws and trying to determine if they violate the current federal law, the Voting Rights Act.
All right, Jessica Levinson, able to get up quickly live for us on CBSN. That was incredible. We so appreciate it. That was great. I think that our audience really benefited from having you and listening to your breakdown of what's going on there in the Supreme Court, because sometimes it's not, on the face of it, things look fairly simple, but they're not, and there's a lot of detail and nuance to some of these arguments, and thankfully you were here to break it down with us.
Oh, such a pleasure. I mean, I live for June. I live for SCOTUS season, so it's really fun to be able to talk about it with you.
Love it. Thank you very much, Jessica.
That is great.
Thank you.